3, 2, 1.
So this is an episode of Scott Talks Law, and welcome once again to another episode of Scott Talks Law. And in this episode, we're going to talk about the relationship between international law and the national law, or municipal law. So international law is that law that deals with the relationship between sovereign states. So this is the law that governs the sovereign states, that regulates the conduct of sovereign states, that is concerned with the state practices, the practices of states. So international laws are concerned with the sovereign states, whereas the national law is the law that deals with the relationship among individuals within a particular nation. So international law is that law that deals with the relationship among individuals within a particular state or a particular nation. So this is the law that regulates the rights and obligations of individuals within a particular state or a particular nation. So the difference is that international law is concerned with the states, whereas the national law is concerned with the conduct of individuals, regulating the rights and obligations of individuals within a particular state or a particular nation. So understanding the relationship between international law and the national law, there are two theories that were developed to explain the relationship between international law and the national law. And these are the monist theory and the dualist theory. So these two theories were adopted to explain the relationship that exists between international law and the national law, the municipal law. So according to the monist theory, the monist theory explains that international law and national law are simply derived from a basic component of knowledge known as law. So these two systems are derived from a single entity of law. So a single entity or a single body referred to as a law. So international law and the national law are simply a manifestation of a single body of knowledge referred to as law. They are explaining that these two legal systems were derived from a single entity referred to as law. So they are just a manifestation of a law, of law, and explains that these two legal systems, international law and national law, operate within the same sphere and deal with the same subject matter. Both international law and the national law operate between the same sphere. So because they deal with the same subject matter, these two systems, international law and national law, can come into conflict. And when they come into conflict, international law is said to prevail over the national law. So according to the monist theory of law, they give more superiority to the international law than the national law. So international law is more superior over the national law. And according to Hans Kelsen, who is a monist positivist, he says that international law says that international law is more superior to the national law, and this is a consequence of his basic norm or his grand norm. And according to Hans Kelsen, the grand norm is that basic principle upon which all other laws gains or obtain validity from. So these two systems are systems derived from the basic norm or the grand norm according to Hans Kelsen. So Hans Kelsen says that international law is more superior to national law, and where the conflict arises, the national courts shall apply international laws. So international laws are superior to the national laws. Professor Hans Lauterpage, who is also was a judge in the International Court of Justice, also asked that international courts or international law is more superior to the national law because international law deals much with human rights, the law that concerns more, or the law that deals or solves a lot of issues that deal with the human rights, and also as tests from common human rights lawyers in the international plane. So according to him, more human rights lawyers can also affirm that international law is the one that is able to deal, is at the best position in dealing with the human rights issues as opposed to the national law, more than what national law can do. National law is only concerned with the individuals, and it does not really deal with the issues of human rights. So according to Professor Lauterpacht, or hence H. Lauterpacht, who is a judge in the International Court of Justice, international law is more superior towards the national law. And also the monist naturalist theory also give their own view concerning the relationship between international law and the national law. And according to the monist naturalist theory, they say that these two systems, the national law and the international law, are simply a manifestation of a simple entity which is referred to as the law of nature. So these two systems are derived from a single entity referred to as the law of nature. And according to the monist naturalist theory, international law is more superior to the national law, and they adopt a hierarchy which explains the superiority of laws, such that the most superior is the natural law, followed by the international law, and the national law comes third. So according to the monist naturalist theory, there must be a hierarchy of laws, and according to this hierarchy, the natural law is at the topmost, followed by the international law. Then the national law, the municipal law, comes third. So that is the relationship. That is according to the monist theory of law, that international law is more superior, and these two systems of law, they deal with the same sphere, they operate within the same sphere, and they deal with the same subject matter.